My name is William Messenger. I'm the Legal Director of the National Right to Work Legal Defense Foundation. This video is intended to provide general information about a private sector employee's right not to be a member of a union. For more detailed information, please review the Foundation's website or contact the Foundation to request free legal assistance. Under the National Labor Relations Act, employees have a legal right to not be a member of a union. Employees who are union members have a right to resign their union membership at any time. And this is true even in a unionized workplace. Employees subject to a union's representation still have the freedom to choose not to be a member of that union. A union employer cannot compel employees to be union members. The closed shop has been unlawful for decades. However, whether non-members of a union can be required to pay fees to a union depend on where those employees work. Employees fortunate enough to work in the nation's right-to-work states cannot be required to pay any monies to a union to keep their jobs. Right-to-work laws prohibit employers and unions from compelling any employee to pay union fees as a condition of their employment. Employees who work in the nation's forced unionism states, however, that lack right-to-work laws can be required to pay fees to a union to keep their jobs. However, as earlier noted, full union membership cannot be required. Payment of full union dues also cannot be required. Under the Foundation 1 Supreme Court decision in Beck, the most that non-members can be required to pay to a union is a reduced union fee for union expenses germane to collective bargaining. Non-members cannot be required to pay for union political expenses, union organizing expenses, or other union expenses not germane to collective bargaining. In a unionized workplace, employees who choose not to be union members are still subject to the union's exclusive representation and all terms of the union's collective bargaining agreement. It is unlawful for either a union or an employer to discriminate against employees who choose to be non-members with respect to wages or their terms of employment. However, unions can reserve internal union membership benefits only to union members. Now, whether an employee chooses to be a union member or a non-member is their personal decision. If an individual who is a union member wants to become a non-member, he or she can do that by simply sending a resignation letter to the union with a copy to their employer. And it is good practice for employees to send resignation letters by certified or registered mail and to keep copies for their records. Sample resignation letters can be found on the Foundation's website. If you want more information about an individual's right not to be a member of a union, or want to request free legal assistance with exercising that right, you can contact the Foundation on its website or by calling 1-800-336-3600. Thank you.